Now, in the time I have left, what I want to very briefly do, summarizing the Roberts Court's first 3.5 terms so far, is focus on 3 core elements of Bush's political coalition and sort of see what they've gotten and not gotten out of the Roberts Court. Social conservatives, first. Now, from the beginning, the modern social conservative movement has been defined in large part as an effort to reverse objectionable Supreme Court decisions. It's been a key set of priorities of the movement, and over time the movement has developed an increasingly sophisticated litigation network to pursue this effort, and this network of social conservative lawyers, both inside and outside of the administration, has won several notable cases during the Roberts era. Let me give you 3 examples. The partial birth abortion case, in which, this was in 2007, the Roberts Court rejected a constitutional challenge to the federal ban on so-called partial birth abortion, which President Bush had signed into law in 2003. That same year, the Roberts Court struck down the race-conscious pupil assignment plans that had been used by public school districts in Seattle and Louisville in an effort to maintain racially integrated schools. And then the following year, earlier this year, the court struck down the strict ban on private possession of handguns that was on the books here in the District of Columbia. Now, all 3 of these were issued by 5-4 votes, and at least 2 of them, in at least 2 of them, it's clear that Bush's appointments produced an immediate change in the law. We know this in the abortion case and the school desegregation case because they both departed from recently decided precedents that had been closely associated with Justice O'Connor, right? So it's clear the replacement of O'Connor by Alito was moving the court in a new direction. It's harder to say in the gun control case because the Second Amendment is a topic that the court has said so little about in the modern era. Its last significant case on the topic was in the 1930s, that we don't really know what O'Connor's view would have been. So it's a 5-4 conservative victory, but it may well be a case that would have come out that way even if O'Connor were still on the court. In any event, they're all 5-4 conservative victories, and in at least 2 of them, Bush's appointments made the difference. Still, you'd have to say that conservatives did not get everything they were looking for out of these cases, as in the Fourth Amendment case, as in Hudson versus Michigan. The conservatives won on the particular case, right? It was a 5-4 vote for a conservative result that conservatives were calling for, but the reach of the change is limited. Right? So, for example, in the partial birth abortion decision, Kennedy's opinion for the court clearly shifted the law rightward, but he went out of his way to characterize the shift as a small step with limited practical effect. In the school desegregation case, Chief Justice Roberts tried to make a more dramatic shift toward the colorblind constitution that conservatives have long called for, but Kennedy refused to join him. Right? This should start to sound familiar. Kennedy wrote a separate and narrower opinion that deprived Roberts of a majority. Right? He joined him in the result, but he was unwilling to say that race-conscious measures are never constitutional. The most far-reaching victory for social conservatives was the gun control case, which reversed a 70-year-old precedent and unsettled a legal understanding that dates back 200 years. It did so to adopt a reading of the Second Amendment that has been a key theme in the contemporary culture wars. But even here, it's too soon to say how far this change is going to go. Scalia wrote the opinion in this case, and he took great pains to indicate that while the district's total ban on private possession of handguns was unusually strict and in conflict with the Second Amendment, most gun control measures, which are more limited and more measured, probably remained constitutional, Scalia went out of his way to say. In sum, social conservatives have certainly had success before the Roberts Court, but given their transformative goals, there remains, I think, a great deal of dissatisfaction regarding the limited progress to date. Now, let's look at economic conservatives, briefly. Now, there's a long line of argument, this dates back to the Reagan years, suggesting that Republican elites have exploited the votes of working-class social conservatives to win office, but have then used their power almost exclusively to enact a conservative economic agenda. And along these lines, some early assessments of the Roberts Court have suggested that its key accomplishments have been legal victories for the Chamber of Commerce. These cases tend to get a lot less attention than the polarizing culture war conflicts, but their practical impact is no less significant. The best known example of such a decision, I think, is Lilly Ledbetter's case. Barack Obama mentioned it in one of the presidential debates with John McCain. This is a gender-based pay equity case decided in a 5-4 decision last year with an opinion by Samuel Alito, throwing out Lilly Ledbetter's pay equity suit because she had waited too long to file the challenge against her employer, and Alito's opinion, which overturned the longstanding position of the EEOC and the judgment of most lower federal courts, held that such challenges must be filed within 6 months of the initial discriminatory pay determination, even if, as is often the case, female employees have no idea that their male colleagues are being paid more than they are, until in Lily Ledbetter's case, on the occasion of her retirement, when somebody slipped her an anonymous note that included confidential salary figures of the company. Right? Nonetheless, she had waited too long, the file, their suit is thrown out. If I had all day, I could give you a number of additional examples of Roberts Court decisions that have been victories for the Chamber of Commerce, to put it bluntly. Right? The court has imposed strict requirements on when investors can file shareholder suits alleging Enron-type accounting and securities fraud. It has closed off a number of product liability suits seeking compensation for harm caused by cigarettes, medical devices, and the like. It has imposed ever stricter constitutional limits on the size of punitive damages that juries can award to punish egregious corporate behavior, most notably in the Exxon Valdez case, where they cut the award to 10% of what the jury had ordered. You get the idea, right? These cases involve a wide variety of legal claims. I'm obviously oversimplifying the allegations and the claims in each particular case. But the practical result of all of them has been to protect corporate defendants against lawsuits filed by aggrieved workers, consumers, and shareholders. Once again, though, I would caution us not to overstate the reach of the conservative shift. The Ledbetter case came down in May 2007, and congressional Democrats have been trying to reverse it ever since. Senate Republicans filibustered the Lilly Ledbetter Fair Pay Act early this year, but both Barack Obama and Hillary Clinton emphasized the issue repeatedly on the campaign trail in the spring. I think it's a pretty safe bet that sometime in the coming Congress this law is going to be enacted. And in the meantime, the court seems to have backed down from its aggressively conservative reading of federal civil rights law. In the term following Ledbetter, the October 2007 term, running from October of last year through June of this year, the justices decided 5 employment discrimination cases, and they sided with the employee plaintiff in all 5 of them. It's hard to read this, I think, as anything other than judicial backtracking in the face of congressional and public criticism. The court's record on federal environmental regulation has been similarly equivocal, with Kennedy more than once jumping ship to depart from the stated policy and legal goals of the Bush administration, and to either weaken a 5-4 conservative decision or to join the liberals for a 5-4 liberal decision supporting robust federal authority in the area of environmental regulation. The last group of conservatives that I wanted to briefly mention, which I'll just say a sentence about, is foreign policy conservatives. And here, I think it's fair to say that they fared even worse before the Roberts Court than social or economic conservatives. And I've got to put a caveat on there. I don't mean to say by any means that that the court has fundamentally thwarted some key priorities of foreign policy conservatives on issues of foreign affairs. The courts tend to get involved only at the margins, right? The court's not going to entertain a case challenging the legality of the Iraq War or anything like that. But where it has stepped in, right, the Roberts Court has handed a series of significant defeats to the Bush administration, including on core priorities of the administration. Lou Fisher talked about these cases a little bit this morning, but in cases like Hamdan versus Rumsfeld and Boumediene versus Bush, and there's another one on the court's docket for this year, we'll see what they do, the court, again, has pushed back pretty hard against the assertions of the unilateral executive authority coming from the White House. Okay, where does that leave us? The Roberts Court has handed a lot of victories to conservatives. If you count up the cases, the Bush administration or conservatives, however you want to count it up, they've won more often than they've lost. It's handed a lot of victories to conservatives. But it has dished out some defeats as well. And the point I've emphasized here today is that even the victories have been incremental ones, right? As such, the judicial revolution sought by conservative Republicans has not come to pass. On a wide range of constitutional conflicts, including some of their top constitutional priorities, they remain 1 vote short on the Supreme Court. They're not going to get that vote anytime in the next 4 years. And if Obama's presidency turns out to be a reconstructive one, ushering in a new era of Democratic Party governance, then we will look back on 2008 as the peak of the GOP's control of the judicial branch, after which it suffered a long, slow decline. Thank you.